Despite the substantial amount of litigation that happens in the United States, the experience of many of us with the American judicial system is really limited to some exposure in traffic court and whatever we may watch on TV, which can be very unrealistic. Most of us experience and have a lot greater understanding of the executive and legislative branches of government than we do know about the judicial branch. So this lecture is going to give you an opportunity to make aware the nature and the purpose of the judicial branch of government. In this entire course, the whole purpose here is to give you an understanding of which courts have power to hear what disputes and when they dispute it. The major concept introduced is called jurisdiction when we're dealing with judicial courts. The requirements for federal jurisdiction and to which cases reach the Supreme Court of the United States is going to be talked about in this lecture. The federal courts are not necessarily superior to state courts. The federal court system is just an independent system authorized by the Constitution to handle certain matters of particular federal interest. An important step in the judicial process is the application of procedural rules in a case. And then the second step to learn is an understanding of what happens before, during, and after civil trials. So we'll talk about civil procedure. Most disputes that do occur in the United States are brought to court and they're settled before a trial even happens. Of those that go through trial to finally end up with a final verdict, less than 4% are reversed on appeal. In a common law system such as what we have here, the cases are the law. Remember, common law. Most of the principles set forth represent judgments in true and real cases that involve real people with real controversies. Jurisdiction is the power to hear and decide a case. Before a court can hear a case, it has to have jurisdiction over both the person against whom the suit is brought or the property involved in the suit and the subject matter of the case. Power over a person is referred to as personam and personam jurisdiction, and that over property is referred to as rem jurisdiction. Generally, court's power is limited to the territorial boundaries of the state in which it's located. But there are cases in which a state's long-arm statute allows court jurisdiction over a non-resident. Corporations are subject to jurisdiction of the courts in any state in which they're incorporated, or where it has its main office, or where it does business. The state court system shows the various types of courts: trial courts of limited jurisdiction, trial courts of general jurisdiction, appellate courts, and then the state Supreme Court. Many state court systems have several tiers, a level of trial courts and 2 levels of appellate courts. Trial courts with limited jurisdiction include local municipal courts, which mainly handle traffic cases, small claims courts, and family court, which we will call domestic relations court. Trial courts with general jurisdiction include county, district, and superior courts. At trial, the parties may dispute the facts, which laws apply, and how the law should be applied. Now, in states after a case is tried, there is a right to at least one appeal. Few cases are retried and go to appeal. An appellate court examines the record of a case, looks at questions of law and procedures for errors by the court. In about half of the states, there's an intermediate level of appellate courts. In all states, there's a higher court, usually what's called the state Supreme Court. the decisions of this highest court on all questions of state law, not federal law, but state law, are always going to be final. If a federal constitutional issue is involved in the state Supreme Court's decision, then that decision could be appealed to the United States Supreme Court. This slide gives you a really good picture of the federal court system. You see the top law of the land is the Supreme Court of the United States. And then you see the various intermediate courts, military appeals, U.S. Court of Appeals for Federal Circuit, and United States Courts of Appeals for the 12 circuits. And then below are the various district courts, tax court, international trade courts, veterans, military. So this allows you to see how the court system operates when a case is heard down at one of the lower courts. It does have the right to be appealed. And then from there, the final law would be in the Supreme Court. The federal court system, we call it a three-tiered, with a level of trial courts and 2 levels of appellate courts. The federal trial courts of general jurisdiction are called district courts. Federal trial courts of limited jurisdiction, which means they only hear specific types of cases, include U.S. tax courts, bankruptcy courts. Federal district courts have original jurisdiction in federal matters. Some administrative agencies with judicial power also have original jurisdiction. U.S. Courts of Appeal or Circuit Courts of Appeal hear appeals from the decision of the district courts within their respective circuits. The decision of a court of appeals is binding on federal courts only in that circuit. And the top court is the Supreme Court, to which further appeal is not mandatory but may be possible. So that is the highest we can ever take a case, is to the Supreme Court. Now, a writ of certiorari is an order to a lower court to send the Supreme Court the record of the party's case for review. The court can still deny the petition. Denying a petition is not decision on the merits of a case. Most petitions that are sent to the Supreme Court get denied. Typically, the court grants petition only in cases that at least 4 of the justices view as involving important constitutional questions. It's noted that there are thousands of cases each year that are petitioned to go to the Supreme Court, but the Supreme Court can only hear about 100 of those cases each year. So it is very limited. And as you know, in this past year, marriage has been an issue of the constitutional of a constitutional matter, and so that is why the Supreme Court has heard issues that can be questioning to the federal statutes. The Supreme Court is, of course, the highest judicial body in the United States. Its membership consists of a Chief Justice and 8 Associate Justices. The justices are nominated by the President of the United States and appointed after being confirmed by the United States Senate. Justices of the Supreme Court have life tenure, receive a salary which is set at $255,000 per year for the Chief Justice and $244,000 per year for each Associate Justice. On August 7th of 2010, Justice Elena Kagan became the 112th justice to serve on the court. This Supreme Court was created in 1789 by Article 3 of the United States Constitution, which stipulates that the judicial power of the United States shall be vested in one Supreme Court, together with any lower courts that Congress can establish. Congress organized the court that year with the passage of the Judiciary Act of 1789. Since that passage of that act, Congress has occasionally altered the size of the Supreme Court, historically in response to the country's own expansion in size of population and states. Membership was decreased in 1801 to 5, then it was increased to 7 members in 1807, to 9 in 1837, to 10 in 1863, reduced down to 7 in 1866, but has been at 9 for quite a while. They're appointed for life. Some choose to retire. A total of 54 justices have retired or resigned. The average age of the newly appointed justices is about 53 years old. Historically, the average length of service on the court has been less than 15 years. However, since 1970, the average length has increased to 26 years. The jurisdiction of the federal courts is limited by the Constitution. Congress has the power to control the number and kind of federal courts other than the United States Supreme Court. Congress can also regulate the appellate jurisdiction of the United States Supreme Court and set other limits on federal jurisdiction, although Congress can't expand it. Whenever a suit involves citizens of a different state or 2 different states, a foreign country and an American citizen, or a foreign citizen and an American citizen, diversity of citizenship exists, and that suit can be brought in a federal court or in a state court. In diversity of citizenship suits, that's a tough word, Congress has set an additional requirement. The amount in controversy must be more than 75,000. So for diversity of citizenship purposes, a corporation is a citizen of the state in which it is incorporated and of the state in which it has principal place of business. Whenever a suit involves a question arising under the Constitution, a treaty, or a federal law, a federal question arises, and that suit can be brought to federal court. Now, we've got exclusive versus not concurrent jurisdiction. When both state and federal courts have the power to hear a case, concurrent jurisdiction exists. When a case can be heard only in federal courts or only in state courts, then exclusive jurisdiction exists. Federal courts have exclusive jurisdiction in cases involving federal crimes, bankruptcy, patents, and copyrights, in suits against the United States, and in some areas of admiralty law. States have exclusive jurisdiction in certain subject matters also, such as divorce and adoptions. So, why a case might be brought in one court or another when there is concurrent jurisdiction is going to be talked about. Generally speaking, that will happen. The people in the case are going to choose the system that is most favorable to their situation. Now, in law, standing is the legal right to bring a lawsuit to court. Usually it requires that the plaintiff or the person who's bringing that case has either been affected by the events in the case or will be imminently affected or harmed if the court doesn't address the problem. Standing is also affected by state or federal laws that apply to the events in the case. Since some laws do not allow injured plaintiffs to sue certain defendants, even if the plaintiff can demonstrate that they were injured by the defendant's actions, can bring a case to court. In personal injury, product liabilities, and similar tort cases, a plaintiff who has been injured almost always has standing to sue the person or the company the plaintiff believes is responsible for their injuries. Depending on the circumstances of the case, these people might include individuals, manufacturers of defective products, businesses that didn't fix hazards on their premises, or others. In a civil case, the pleadings inform each party of the other's claims and specify the issues of the case. The pleadings consist of a complaint and an answer. The complaint or petition, or can be called declaration, is filed with the clerk of the trial court. It contains a statement alleging jurisdictional facts, a statement of facts entitling the complainant to relief, and a statement asking for a specific remedy. A summons is a copy of the complaint, and a summons is served on the party against whom the complaint is made. The summons notifies the defendant of his or her options: file a motion to dismiss the complaint, file an answer, or default. After receipt of the complaint and summons, this would be a motion to dismiss may be based on several grounds. A motion to dismiss for failure to state a claim on which relief can be granted alleges that according to the law, even if the facts in the complaint are true, the defendant is not liable. An answer admits or denies the allegations in the complaint and sets out any defenses or any counterclaims, which is where the plaintiff can file a reply to that counterclaim then. In regards to motion to dismiss, besides a plaintiff's failure to state a claim on which relief can be granted, a defendant's pre-answer motion to dismiss may be based on the court's lack of subject matter or personal jurisdiction, improper venue, insufficiency of process or service of process, and the plaintiff's failure to join a party needed for a just adjudication of the controversy. Or the defendant may raise these defenses in his or her answer. Some of these must be raised at this stage or they'll be deemed waived. A defendant may also move for dismissal on the grounds of the plaintiff's failure to diligently prosecute his or her claim or to comply with procedural rules or a court order. Other pre-answer motions include a motion for a more definitive statement, which may be made if a pleading is so vague or ambiguous that a response can't reasonably even be framed. A motion to strike such matters, for example, an insufficient defense, and a motion for summary judgment through which the moving party asserts there's no genuine issue of material fact, and he or she is entitled to judgment as a matter of law. After the pleadings are filed, if no facts are in dispute and only questions of law are at issue, either party can file a motion for judgment on the pleadings. A trial might also be avoided if no facts are in dispute and only questions of law are at issue. In that case, either party files a motion for summary judgment. In rulings on this motion, a court can consider evidence outside the pleadings. To prepare for trial, parties obtain information from each other and from witnesses through the process of discovery. These discovery devices save time by preserving evidence, narrowing the issues, preventing surprises at trial, and avoiding a trial altogether in some cases. There are 4 types of common forms of discovery: depositions and interrogatories. Discovery can involve the use of depositions, interrogatories, requests for admission, requests for physical or mental examination, requests for documents, objects, and entry upon land. A deposition is a record of the answers of a party or witness to questions asked by the attorney of both plaintiff and defendant. Interrogatories are written questions asked of a party who responds in writing. Other information: a request for an admission is a request that a party admit the truth of a matter. A request for a physical or mental examination will be granted only if the court decides that the need for the information outweighs the examinee's right of privacy. A request for documents, objects, and entry upon land is a request for access to these items to inspect them. E-evidence for discovery is any relevant material including information stored electronically, such as email and other computer data, can be the object of discovery request. This may include data that was not intentionally saved by a user, such as concealed notes and earlier versions. The trial begins with the attorney's opening statements. These statements concern facts that they expect to prove during the trial. Because the plaintiff has the burden of proving his or her case, the plaintiff's attorney calls and examines the first witness. This is called direct examination. The defendant's attorney then cross-examines the same witness, after which there's an opportunity for redirect and recross examinations. In a jury trial, after the plaintiff's case has been presented, the defendant can move for a directed verdict or judgment as a matter of law in federal courts, which the judge grants if he or she believes that the jury could not find for the plaintiff. If this motion is denied, the defendant's attorney presents the defendant's case. At the end of the defendant's case, either party can move for a directed verdict. If this motion is denied, the plaintiff's attorney can refute the defendant's case in a rebuttal, and the defendant's attorney can meet that evidence in a rejoinder. After both sides have rested, the attorneys present their closing arguments, the jury is instructed in the law that applies to the case, and the jury retires to consider a verdict. After the verdict, the losing party can move for a new trial or for a judgment notwithstanding the verdict. If these motions are denied, he or she can appeal. To appeal, the appellant files the record on appeal, which contains the pleadings, a trial transcript, copies of the exhibits, the judge's rulings, arguments of counsel, jury instructions, the verdict, post-trial motions, and the judgment order from the case. The appellant files a brief which contains statements of facts, issues, applicable law, and grounds for reversal. The appellee files an answering brief. The court reviews these records, the attorneys present oral arguments, and the court affirms the lower court's judgment or could reverse it and remand the case for a new trial. If this court is an intermediate appellate court, the losing party can file a petition for leave to appeal to a higher court. If the petition is granted, the appeal process is repeated. Most decisions of a state or federal trial court are subject to review by an appeals court, including decisions regarding almost all types of civil cases. Whether the appeal concerns a judge's order or a final judgment entered by a jury, an appeals court reviews what happened in the proceedings for any errors of law. If the court finds an error that contributed to the trial court's decision, the appeals court will reverse that decision. The lawyers for the parties submit briefs to the court and may be granted oral argument. Once an appeals court has made its decision, the opportunity for further appeals is limited. The number of parties filing appeals has risen substantially in the last few decades, causing the state and federal court system to implement changes in an effort to keep up. A trial and an appeal have a few similarities, but also have many important differences. At trial, the parties present their cases, calling witnesses for testimony, and presenting other pieces of evidence such as documents, photographs, reports, surveys, diaries, blueprints. The jury weighs this evidence and determines the facts of the case, that is, what they believe actually happened. A jury is therefore sometimes referred to as the finder of fact. The judge controls the activities in the courtroom and makes all the legal decisions, such as ruling on motions and objections raised by the attorneys. The judge is often called the finder of law. If the parties have chosen a bench trial rather than a jury trial, the judge will make both findings of fact and findings of law. An appeal is a review of the trial court's application of the law. There is no jury in an appeal, nor do the lawyers present witnesses or other forms of evidence. The court will accept the facts as they were revealed in the trial court, unless a factual finding is clearly against the weight of the evidence. Another difference between a trial and an appeal is the number of judges involved. A single judge presides over a trial. An appeal, however, is heard by several judges at once. How many depends on the jurisdiction. At the initial appeals court level, courts may have from 3 to a few dozen judges. Yet on the larger courts, the full number of judges seldom hear claims together. Instead, appeals are typically heard by panels, often comprised of 3 judges. In rare instances, the full court may decide to grant a motion for rehearing in banc, in which events all the judges on the appeals court to hear the case together and issue a new decision. Supreme Courts at the state and federal level have from 5 to 9 judges, referred to as justices. Technology can save judges and lawyers time and space. Filing court documents may involve a transfer over the internet, a transmission via email, or a delivery of a computer disk. Courts are also using electronic case management systems. Most courts also have websites. Next on the horizon are virtual courtrooms, or potentially cyber courts. Alternative dispute resolution. The advantage of ADR is its flexibility. Normally, the parties themselves can control how the dispute will be settled, what procedures will be used, and whether the decision reached, either by themselves or by a neutral third party, will be legally binding or non-binding. Approximately 95% of cases are settled before trial through some form of ADR. One form of ADR is negotiation, in which the parties attempt to settle their dispute informally with or without attorneys. They try to reach a resolution without the involvement of a third party. In mediation, the parties attempt to negotiate an agreement with the assistance of a neutral third party, a mediator. Mediation is essentially the form of assisted negotiation. The mediator takes an active role in resolving the dispute, but does not make a decision on the matter being disputed. Formal arbitration resembles a trial. The parties may appeal, but a court's review of an arbitration proceeding is more restricted than the review of a lower court's proceeding. An arbitrator's award will be set aside only if the arbitrator's conduct, or bad faith, substantially prejudices the rights of the parties, if the award violates public policy, or if the arbitrator exceeded his or her powers. When outside help is needed to resolve a dispute, there are a number of websites that offer online dispute resolution. ODR may be best for resolving small to medium business claims, which may not be worth the expense of litigation or traditional ADR. Most online forums do not automatically apply the law of any jurisdiction. Any party may appeal a dispute to a court at any time. A dispute arises between Harry, a resident of California, and Maria, a resident of Texas, over the ownership of a FAIRWEATHER, a sailboat in dry dock in San Diego, California. Can a California state court exercise jurisdiction over the dispute? Yes, it can. The boat is located within the boundaries of California, so a California court can exercise jurisdiction.